Good afternoon, I'm Shivani, and today we are going to talk about the doctrine of eclipse under the constitutional law. So, to begin with, judiciary is the guardian of the rights provided under Constitution of India, and it is a job of the judiciary to restrain the actions of the legislature as well as the executive. What the judiciary does is keep a check on the actions provided by the legislature as well as the executive, whether they are infringing the fundamental rights or the legal rights of people or not. So, what amongst all this comes the constitutional rights, among which the power of the judiciary is the doctrine of eclipse. So, what does the doctrine of eclipse mean? The doctrine of eclipse states that any law which is inconsistent with the fundamental right is invalid, which means it is not totally dead or it is not totally invalid, but it is overshadowed to the point that infringes the fundamental right. For instance, one act is made. Among that act, one section infringes the fundamental rights of people. In that case, the doctrine of eclipse goes over to that section which infringes the fundamental right of the person. The inconsistency can then be removed by a constitutional amendment. So, what happens in this? There are several existing laws at the time when the Constitution was adopted in the year 1950, some of which were in direct conflict with the fundamental rights. So, in order to determine the validity of these laws, Supreme Court came up with certain principles and doctrines. One of those principles and doctrine is the doctrine of eclipse. What does this doctrine state? This doctrine states comes directly from Article 13.13 Clause 1 of the Constitution, that is a part of the fundamental rights, which states that all laws in force of the territory of India immediately before the commencement of the Constitution, insofar as their inconsistence with the provisions of this part, that is Part 3, shall to that such extent of inconsistency be void. This is the doctrine of eclipse that emanates directly from Article 13, Clause 1. The doctrine of eclipse envisages fundamental right as prospective in nature, which means the doctrine is not retrospective but prospective, which means upon the date of the formulation of that particular law, once determined that that law is inconsistent with the fundamental rights, it will not affect the decisions or the judgments made previously before that law was enacted, or before that law came to be inconsistent, but it will go on after that. It states that pre-constitutional law inconsistent with fundamental rights is not a nullity or void ab initio, but only remains unenforceable, which means it remains in a very dormant state. Neither is it null nor is it void ab initio, but it only remains unenforceable. They exist for all past transactions, that is for rights as well as liabilities that were acquired before the Constitution came into being. These laws also remain applicable to individuals who have not been given fundamental rights. For example, the non-citizens of India. This fundamental rights or Part 3 of the Constitution goes on to cover citizens as well as non-citizens of the country. Therefore, this law remains hidden behind the fundamental rights and can become operative again if and when the fundamental rights is inconsistent as and when amended. Now, there are some really important cases that came into being once to determine this doctrine of eclipse and the power that the judiciary holds while determining to what extent can the doctrine of eclipse be used. Court rulings related to the doctrine of eclipse. The doctrine of eclipse has evolved through various Supreme Court rulings after the adoption of the Constitution in the year 1950. After that, so many cases came into being, so many acts came into being, so many amendments were made, through which it was important to determine that the fundamental rights of the citizens are not violated. In that, one of the case, that is, in Keshav Madhav Menon versus State of Bombay, the petitioner was prosecuted under the provisions of the 1931 Indian Press Emergency Powers Act for publishing a pamphlet with no permission. The case was still pending when the Constitution came into force, and thus it raised the questions regarding the prospective and retrospective nature of Article 13, Clause 1 and the word void. The question before the court was whether this impugned act, that is the Indian Press Emergency Powers Act, was violative of Article 19, Clause 1, Clause A, and if so, whether it should be declared void. The court answered the first part, that is, the question that whether the impugned act was violative of Article 19, Clause 1, Clause A. In that, the court answered that yes, it was violative, adding that the act is void only to the extent of that violation, and the word void used in Article 13 does not mean that the statutes or the provision shall be repealed altogether. This basically sums up what exactly the doctrine of eclipse means. In this particular case, the entire act was not done away with, neither was the entire act repealed, but only that provision which restrains the person's right that under Article 19, Clause 1, Subclause A, only that part of the provision was declared void, which means it was not void ab initio, but it came into being only to that part of the act which was inconsistent with the fundamental rights of the person that came into being as void. The second case is, one of the other famous case is FN Balsara. The court declared under this case that Section 13 Clause B of the Bombay Prohibition Act 1949 as void because it violated Article 19 Clause 1 Subclause F of the Constitution. The court again held that only the part of the statute, that is the Bombay Prohibition Act of 1949, only Section 13 Clause B is to be held as void, which was the only part of the entire act which was held to be violative of Part 3, that is violative of fundamental rights, and is inoperative and not the entire statute. It is generally agreed, however, that the actual genesis of the doctrine occurred in one of the most important cases, which is Bikaji Narendra Kas versus State of Madhya Pradesh. In this case, the CP and Berar Motors Amendment Act of 1947 was challenged for being violative of Article 19, Clause 1, Subclause G. This amendment was a pre-constitutional law, which means it was enacted before the Constitution came into being. Thus, the doctrine of eclipse applied to the Act's provisions and were made inoperative to the extent that this Act was violative of fundamental rights. However, in the year 1951, by the virtue of First Constitutional Amendment Act, 19 Clause 1, Subclause G, was amended and the eclipse was removed, rendering this law enforceable against citizens and non-citizens. According to the court, the effect of the amendment was to remove the shadow and to make the impugned act free from all blemish or infirmities. What are the salient features of this act? The doctrine of, now let us discuss what exactly the important features of the doctrine of eclipse. The doctrine of eclipse applies only to pre-constitutional laws that were valid at their inception, which means after the coming of constitution, these pre-constitutional laws which were valid at their inception had to be dealt with and had to be decided whether they were violative of fundamental rights or not. The doctrine is not applicable to post-constitutional laws since they were invalid from the very inception of being inconsistent with Part 3. That is, once the Constitution was established and another act is made, any act which is made inconsistent with the Part 3 of Constitution, that is part against the fundamental rights, is void ab initio, which is why any act which was made prior to the Constitution of India is void to the part that is violative of fundamental rights, which is why this doctrine does not apply to post-constitutional laws. This same was held in the case of Deep Chand versus State of Uttar Pradesh, where Supreme Court said the same thing, that it is not applicable to the post-constitutional laws, but is applicable to pre-constitutional laws. The impugned law, which was made before the commencement of the Constitution, must be violative of fundamental rights. Only then can it be hidden or eclipsed from the rest of the law. The law that turns out to be violative of Part 3 does not become a nullity, but it remains unenforceable and defective. it is not null or it is not void ab initio, but it becomes defective and inconsistent to the part that it is violative of part 3. If the fundamental right that is violated by the impugned law is amended in future, the law automatically becomes operative, which means a law which was dormant or stagnant or dead gets revived again if there is an amendment to the part 3 of the Constitution, wherein which makes this law non-violative in the near future. In this case, this law becomes operative again, as it is not completely destroyed or it is not completely void, it is not completely invalid. It is only invalid to the point that this part was violated, once violative of fundamental rights. Once the fundamental rights itself is amended, this part again can become operative. The judgments of Deep Chand, Bikaji and Deep Chand were upheld in the case of Mahendra Lal Jain versus State of Uttar Pradesh, State of Gujarat versus Ambika Mills, Sagar Ahmed versus State of Uttar Pradesh, and P.L. Mehra versus Dr. Khanna. These are the same case in which all these doctrine of eclipses were determined, and the overshadowing power of the judiciary, the judicial reach, was determined through doctrine of eclipse. Now, summing it up, doctrine of eclipse is one of the fairly subtle principles of rule of law that has helped pre-constitutional laws from being wiped out altogether. This is because once the Constitution came into part, the entire Act cannot be done away with, but only the certain provisions of the Act could be done away with. It is imperative to mention here that the applicability of this doctrine to post-constitutional laws is somewhat still a gray area, because one cannot determine how it would affect, how the doctrine of eclipse would play a role when the Constitution itself has made a certain act void ab initio for being inconsistent with the fundamental rights. However, this doctrine has been effective in harmonizing the pre-constitutional and post-constitutional positions with respect to various laws, such harmonization has ensured that the constitutionalism spirit remains triumphs in every sense and every word. So, doctrine of eclipse is contained in Article 13, Clause 1 of the Indian Constitution. And Article 13 states that any law which is made before the commencement of the Constitution must be consistent with the Part 3 of Indian Constitution. If any statute is inconsistent with the provisions provided under Part 3 of the Constitution, that statute, or to the extent of that part, would become void. Now, coming to doctrine of eclipse and doctrine of severability, one of the most frequently asked difference is that doctrine of eclipse cannot be invoked in the case of post-constitutional law, which is it cannot be invoked if the law is made after the commencement of the Constitution, whereas the doctrine of severability makes the law void ab initio. Owing to Article 13, Clause 2 of the Constitution, limitations are laid upon the legislature to adhere to the fundamental rights of the Constitution, which is why this doctrine of eclipse had come and came and is applicable to laws which were made before the Constitution came into being. So that was what it was today's class about, the doctrine of eclipse and what it means, and what is the scope of the judiciary to limit the deal with the doctrine of eclipse, and how far is the judicial reach under this case. Thank you.